You might have a child who's turning 18 and somebody has told you, you should conserve your child. You should get a limited conservatorship for them. And you're wondering, do I really need to do that? What's involved with that? We're going to talk about all of that in this video. Hello and welcome to my channel. My name is Ellen Cookman and I'm an estate planning attorney who specializes in special needs planning. On this channel, we're going to talk about how to set up a special needs trust to protect your loved one who has special needs. We'll talk about the importance of setting up a trust, what's the difference between a regular trust and a special needs trust, regular estate planning, a revocable living trust, how to avoid probate, trust administration, and many other relevant topics. If this information sounds useful to you, please consider subscribing and hitting the notification bell so that you'll be notified when new videos come out every week. I'm a certified specialist in estate planning, and my law firm has helped hundreds of families navigate the complicated process of setting up their estate plan with special needs components. I'm excited to share all of the knowledge that we've learned over the years with you. So in California, there's 3 different types of conservatorships. A conservatorship is basically where you go to court and you ask the judge to allow you to make decisions on behalf of somebody else. The conservatorship that we're most familiar with is a general conservatorship. I believe that's the type that Britney Spears was under, where somebody else was able to make her decisions about financial management. But usually we see this type of conservatorship with the elderly, they have dementia, they have other issues, and someone else needs to step up to manage their assets, decide where they live, that sort of thing. For a child with developmental disabilities, when they turn 18, all of a sudden they become an adult. Even if they're disabled, they're still expected to make their own decisions. Well, this is really problematic, you could imagine, because now you can't attend their IEP for their school without their child's permission. The doctor may not talk to you or give you the medical records. So what are you supposed to do in this situation? So there's a few things you can do. One thing, if your child has capacity, you can have them sign a durable power of attorney and advance healthcare directive. In fact, everybody, when your child turns 18, they should sign those 2 documents, which voluntarily allow you to take steps on their behalf. It allows you to attend their IEPs. It allows you to access their medical records. But what if your child can't do that, or if you're afraid that something might happen? Okay, so here are the scenarios that I typically see where parents really want to conserve their child, because I don't think it's a slam dunk. Not every child, just because they have a developmental disability, needs a conservatorship. But your child might be out there in society and might be vulnerable to financial predators. Somebody might come and offer them a Visa card, and then they charge $50,000 for a round-the-world cruise that they're never going to use, right? Or perhaps your child is not very cooperative when it comes to making decisions for their health care. They won't get the shot that they need or the surgery. And so you really need to dictate their medical decisions. In those situations, it can be very appropriate to go to court and ask the judge to make you the conservator over your child. So there's some pros and cons to this. You need to think about, how will your child react to this? Some children are really relieved. They're like, oh, good. My parent can still continue to make decisions on my behalf. That's great. That's really a relief. Other children may not like this at all. They want to be more independent. They're like, I'm 18, now I get to make my own decisions. One thing you should know during the conservatorship process is that your child will get a chance to say what they think about this. And if they don't like being conserved, then you may not get the conservatorship. So here's what the process basically looks like. All right. First, if I were doing a conservatorship, I would speak with you and collect a lot of information from you. Okay. And so then we have to fill out a lot of court forms and file them. So these are forms talking about your child, why your child needs to be conserved, what are your child's issues. You need to fill out a supplemental information form about you that says that you don't owe your child any money, they don't owe you any money, you're not a convicted felon, just different information about you. It's kind of a screening process. even if you're the parent, even if you are the number one choice, they still want to go through the screening process. Whenever you're dealing with a child that is a minor or has disabilities, the court wants to make sure that whatever they order is the right choice. Okay. You also need to have your doctor or your child's doctor fill out something called a capacity declaration, where they talk about your child's capacity and how they can do things. Okay. So you collect all of this information and you file it, and then you get a hearing date. And the judge will appoint a court investigator to interview everybody, to interview your child, interview you, perhaps interview some family members or friends. You would provide that information to them as well, to make sure that you are the right choice as conservator. The judge will also appoint someone to represent your child. Okay, this might be a private attorney, it might be the public defender, but somebody will interview your child and represent your child in this case, and make sure that your child's on board with this, or perhaps your child is okay with most of the powers, but not all of them. The reason why it's called a limited conservatorship is because you're asking for certain powers over your child. So you're saying, I want the power to decide where my child lives. I want the power to make education decisions. I want the power to make healthcare decisions and enter contracts. There's two powers that typically, at least in San Mateo and Santa Clara counties where I practice, judges don't allow those. And that's the power to get married and the power over social and sexual relationships. They want to leave those just for the child. Now, so you have to spell out which powers you want. And that's why we call it a limited conservatorship, because you're limited to the powers that you ask for and the powers that you're granted. If this information is resonating with you, we ask you to hit the like button so YouTube can get this information out to more families who might need it. Okay, so once you have all of these interviews that have taken place, then you go to the hearing. The judge has all the information. They've written up reports. The one other report that you'll need is from the regional center. So your child must be a member of a regional center in California. These are nonprofit organizations that contract with the state of California to provide services to developmentally disabled individuals. Now, note that I didn't say services to those with mental health challenges or to those with physical challenges. It's only for developmentally disabled individuals. So to get a limited conservatorship, your child must, and I repeat, must be a member of a regional center. In San Mateo County, it's part of the Golden Gate Regional Center, and in Santa Clara County, it's part of the San Andreas Regional Centers. But there's regional centers all over California. So depending on where your child lives, that's where they would be a member of the regional center. So if your child is not a member of the regional center, or if they were before and now they're not, you'll want to get them signed up again, because the regional center will be writing a report to say whether your child needs to be conserved. So after all this information is provided to the court, then the court makes a decision. So at the hearing, they'll let you know, is it granted or not? If it's not granted, typically you'll find out beforehand. But, so usually it's granted. You need to appear at the hearing. Nowadays, as the time of this recording, it's great because we can do the hearings over Zoom. So that's been really convenient. And so parents can attend with your child there and just answer a few questions for the court. And then you are granted what we call the limited conservatorship papers. It's a 2-page form that you can give to the doctor, that you can give to the school district. And this allows you to take steps on their behalf. So that's the gold. That's what you're trying to get, is the limited conservatorship papers. Okay, so that's all about limited conservatorships. It usually takes 4 to 6 months from start to finish. And if your child is not yet 18, usually we start about 6 months prior to their 18th birthday to get this set up. However, if they're over 18, that's okay. They can still be conserved. It's not like it only happens on your 18th birthday, but it's your 18th birthday that's the earliest, because before that, you are making decisions for your child. So you can see this is a complicated process. It takes some time. Whenever you're going through the courts, it takes time and it takes money and effort. So you should think carefully, do we really need to conserve our child? Or should some of those other options, like a durable power of attorney or advanced healthcare directive? Do those make more sense? Or there's also another option called supported decision making. And if you look that up on the web, there's a great website that talks all about that. That's all about getting a supportive group of people to help your child make the right decisions. So as we're learning more about developmental disabilities and helping people, there's going to be more and more available resources. For more information on limited conservatorships and whether you might need one for your loved one, I've done a full-length webinar on this, so I ask you to click on the link below so you can access that webinar. So if you have a child with developmental disabilities, you'll also really benefit from this video on how to set up a special needs trust in California. So watch this video and I'll see you there.